We're going to start out with this next panel. We got our panel here of esteemed prosecutors from across the country. And we wanted to bring them to you because they are much more experienced than I am in this area. Our passion may be equal, but their experience is much greater. And a lot of the questions I'm going to ask them is because, quite frankly, I want to know the answers to them too. There are a lot of challenges in these type of cases, as we all know so far. And regardless of what your position is, as we indicated and you guys have heard over and over again, the common goal is to make sure that we get it right. So bring in prosecutors who have done countless numbers of wrongful conviction cases. We thought that we could try to develop what we call best practices, because we've go to centers like the Quadron Center, who bring prosecutors all the time together. We go to different jurisdictions and see how they do it. But for once, we wanted to bring it to Cleveland. So I want to start by asking Mr. David Angel from Santa Clara, California, the first CIU, recognized CIU in the country, to begin by introducing himself.
Hi, well, I'm David Angel. I'm from Santa Clara County, and if you're not from California, that's south of San Francisco. It's the city of San Jose. So it's an interesting county in that we have both like Google and Cisco and Apple and all these very big high-tech Silicon Valley companies, but we also have San Jose is a pretty major city, and then Gilroy is kind of a ranching community. So we have a pretty diverse population. So let me just speak very, very quickly. We founded our unit in about 2004. We have both a proactive and a reactive component to it. The reactive, of course, is responding to cases that come to us or crises that come up. At this point, we've reviewed, I don't even know how many, but certainly well over 100 cases. We've had 6 exonerations out of the unit. But at this point, I would say our bigger focus, or my bigger focus, is proactive. And what I mean by that is trying to derive some lessons from not just our cases, but from the speakers you've heard before, and the lessons that we're trying to learn on what can we, if you begin to shift your focus from, I think as some said, like pointing fingers, something went wrong, so somebody must be at fault, and instead began to look at it as a system, and in any system there's going to be errors. Well, what are the sources of those errors, and what can you do to reduce the risk of those errors happening again? And that has a lot of benefits. First of all, just a lot easier to make progress that way, but it also makes it a lot easier for prosecutors or police, and my focus more on prosecutors with my office. People can acknowledge errors. They're not likely to acknowledge misconduct, right? But if you ask any prosecutor, and any prosecutor I've asked, do you think you would ever make a mistake during the course of your career? They'll all say yes. And people, and by creating that safe harbor to recognize that no matter what you did, there could have been an error, and maybe you made it, maybe somebody else made it. People are much open to identifying it. Some of the policy reforms that we have looked at have been eyewitness identification, and so we've been doing that actually for a pretty long time now. With in addition to the things that Rebecca talked about, double blind, we do our sequentially, confidence statements. We also will videotape the actual identification procedure, which is really invaluable. We have a Brady committee, I think, which somebody else talked about. And have worked out memos of understanding with all the local law enforcement agencies. So we have agreements in place with them so that, to make sure they're providing us the information we need. We have through this unit, we've worked on a policy on recording statements. So we record virtually every statement, but certainly all suspect statements, whether they happen in the field or in the police station. We have body-worn camera policies. And one that I think has been particularly helpful, we have a prosecutorial misconduct protocol, and this allows for essentially it's a mechanism or a protocol that triggers when there's an allegation of misconduct. And by doing that, we try to pull it out of the hands of the prosecutor who's been accused for a bunch of reasons. First of all, just not nobody should have to defend themselves, right? And secondly, they shouldn't have to defend themselves because they're suddenly biased, right? They have a motive in the outcome of this hearing. We want to make sure it was more neutral, but also more fair. Our CIU also works hand in glove with our crime labs so that when you have emergent issues happen, like hair microscopy or DNA mixture issues or other forensic issues, that you're able to look at this with this kind of conviction integrity focus on it. And then we've even shifted now more into areas. There's a huge overlap between policies that are going to reduce those risks of wrongful convictions, but also looking at policies that will take some of these same values into account when looking at the majority of our cases where people are actually guilty. And in some ways, it's born from trying to create a culture where you're humanizing all the people in your community, including those who are guilty of committing crimes. So not just thinking of them as a them, but as valued members of our community, even if they have to be held accountable for sometimes very bad things. So we've been really focused a lot on collateral consequences, which is a big issue in California. As you know, right now, we've been the subject of significant attention by Jeff Sessions and Donald Trump because of that. So there's litigation to try to defund our county. But we've also been working on bail reform and are really in the mix on that, and fines and fees. One of our big areas working on a lot now is, I was shocked when I began working on this a year and a half ago or so, to find out that the larger purveyor of mental health services in Santa Clara County is our county jail. I mean, it's utter madness once you realize that every individual step might have made sense, but your endpoint cannot be that your county jail is your main provider of residential treatment for the mentally ill. I mean, it's a terrible system, and of course it really skews everything that's happening in the criminal justice system. And talk about a disparity when people are negotiating cases if somebody is severely mentally ill. I mean, obviously they're not negotiating it, but it skews the entire system in terrible ways. And then just this last year, Jeff Rosen, my DA, he supported, and with assistance, and was passed and signed by the governor, a new law that allows elected DAs to recall sentences. And the metaphor in some ways is we have people who are guilty of the crime, but they're not necessarily guilty of the sentence they received. And so we wanted some mechanism that we could revisit these cases where it seemed there had really been a miscarriage of justice. And that now has become law, throughout the state, and we'll see, what impact that has. So anyway, I just wanted to lead with, the conviction integrity unit can really begin to be shaped by the office, but also to shape the culture of the office in these larger, maybe policy ways that are born out of the experience you have on working these individual cases. So that's kind of what we're focused on now.
Okay. Don, do you mind going next?
Sure. So in Tarrant County, the Conviction Integrity Unit began in July of 2015 when the current CDA, Sharon Wilson, took office. Actually, she took office in January, but it took a couple months to get it all passed through the commissioners, and anybody who deals in government knows that. Anyway, we have a very similar structure. We have our proactive and our reactive side, and so certainly everybody's very familiar with the actual innocence cases, and we also will look at wrongful convictions. They make a claim of actual innocence, and if it turns out to be perhaps short of actual innocence, but there's other conviction issues, then we will examine those as well. We don't just do writs again, though, not time cuts, not IAC, things like that on their own. But then on the proactive side, we have had best practices that we are addressing, in particular as they relate to some of the actual innocence claims. So the Jailhouse informant procedure that was talked about earlier with Rebecca, that actually came out of an innocence case. And I actually joke sometimes that, and I want to talk about it a little bit more later, but I joke that I went to the Brooklyn Summit and heard about, these cases that all involve the same witness. And I was like, well, how did nobody know that that same witness was involved in all these murder cases? And then little did I know, well, how did we not know that the same jailhouse informant was involved in all the cases in Tarrant County? And you realize people aren't tracking that. We're not paying attention in an office with 200 prosecutors. I don't know how many y'all have, but 500. You're not paying attention to every witness that's offered in every case. You can't possibly do that. And so again, it goes back to some of the things Rebecca and the other panel was saying, that it has to do with just human error, human factors, and it's not malfeasance. So we had that. We also have a very active Forensic Science Commission, and so we attend all of those. We recently, our Forensic Science Commission is also requiring the legislature required the licensing of analysts. So in addition to being an accredited crime lab, our analysts have to take a licensing exam. And part of that licensing exam includes human factors, includes bias, and also includes Brady. So one of the things that we helped with in the Conviction Integrity Unit is to formulate the tests that the analysts have to take in order to show that they have a clear understanding of their Brady obligations. And as part of that, we also came up with some procedures that relate to forensic disclosures. We don't have an MOU with them specifically, but we have a disclosure compliance policy for both law enforcement and for forensics, and that is something that really takes a lot of time if you are seriously doing that correctly. There's a lot that's involved with manning that database. So we do have a lot of proactive measures going on at the same time. One of the things that I would like to speak to is that our Conviction Integrity Unit, there are 3 attorneys, a full-time investigator, a part-time investigator, and also a full-time support staff paralegal. And everybody was talking earlier, and I think there was a question about how do what do you do with regard to your confirmation bias, or what do you do about the biases that people have? And when I started, I was a defense attorney. I'd been a prosecutor before that. But I thought, I'm a really neutral person. It's a good thing to have me do this. And what I ended up realizing is none of us are neutral. You're just not. And so you just need to embrace that and figure out what to do about it. So in my unit, one of the things that we did is hire people that are not like me. So I have one person who is a career prosecutor, Secret Service agent, former police officer. I have an academic who was at a court of appeals, staff attorney, who thinks theoretically that everything in the world is possible. She has the best intentions, but I'm constantly real world, And then I have an investigator who was a cold case unit person and a homicide investigator, and it's just bringing in people that have different perspectives, and we just fight. And the idea is we staff every single case. If it's assigned to you, we still staff it together. If anybody disagrees, you get to go back and do more. And I feel like we have to kind of get away from this idea that we're all going to be able to come to some like-minded neutral position and go forward. And we have to just embrace the fact that we have different perspectives. And what I employ that I didn't realize, because I'm not a science person until it became part of my job, is what I think that we end up using is the scientific method. You take whatever position that you believe in, and then you try and disprove it. And if you can still reach the same conclusion after legitimately, seriously looking through that with that lens, then I think you have a better chance of coming to something that not as only is the truth, but that other people can see is the truth, and that you spent an appropriate amount of time vetting that so that they feel confident in what it is that you're doing. So I know that I'm going to give some time back.
Okay. What?
I know.
How about you, Cynthia?
So I'm Cynthia Garza. I'm the chief of the Conviction Integrity Unit in Dallas. Our unit was started in July of 2007. We're the longest continuously operating unit in the country. We take the majority of our work is in casework. That's what we've been doing since the time that our unit started. But we also do some proactive measures as well. That stuff really kind of started after our casework really kind of got off the ground. We've had 37 exonerations so far in Dallas County. We have 2 that are pending at the Court of Criminal Appeals, so I can't really count those guys yet. But, you know, we started off with 2 prosecutors in the unit. I've been serving in that unit since January of 2010. So for 10 years, we worked with 2 prosecutors in the unit, 1 investigator that we kind of shared with a different division, and a dedicated support staff. That is what our unit was made up of for the longest time, until our current elected DA expanded it this year, and she added an additional prosecutor, which was amazing because there's so much work to be done. When you have any exoneration that goes on around the country, even in Dallas County in particular, you get flooded with people wanting case reviews. I get people asking for case reviews from places that are outside of our jurisdiction, outside of our state even. And so what we do is we take a look at every single letter that comes into our office, every single request for review. So as you can imagine, we get about, you know, on average about 200 or so a year. Every year is different. Sometimes it's higher, sometimes it's lower, depending on what's going on in the news. But we get a bunch of requests for review. So our dedication is to sifting through all those requests for review, seeing which ones we can take for a full-blown investigation. So there's criteria. Most of the time you have to follow the criteria of what, you know, what the law requires. Obviously, if you're looking at a case and it looks like a lot of legal options might have already been exhausted, sometimes you have to think outside the box, but that doesn't mean that you are able to move forward with the investigation and be able to, you know, ultimately agree to relief on something. So you have to think about those things as well when you consider whether or not you're going to accept the case in the CIU. But you know, it's a lot of our time is spent in evaluating cases and reviewing cases. Then a lot of what we do as well is investigating. We do our own investigations through our investigator, who is now, thanks to our current DA, she gave us a dedicated investigator who works on our cases. So we investigate our own cases, and then if it comes time for litigation, we do our own litigation. We do the state's response, we help draft the findings of fact that go down to the Court of Criminal Appeals and things like that. There are some CIUs that they don't handle their own litigation, but we do. We also are involved in policy making in our office. You heard Dawn talk about discovery compliance policies. We had a discovery compliance policy in our office, but it wasn't quite what it is now. So I'm sure later on we'll talk about the multi-county policy, but it's been revamped, and so we had a say in that. We also had a say in establishing the Jailhouse informant policy that our office has. And we're also involved in training. So a lot of the stuff that we do in terms of training is in-house. We train our own prosecutors, but we also go to our local law enforcement agencies. We train them. We train other prosecutors. We train defense attorneys. It's just, you know, going around just sharing what we've learned and best practices and things like that that will help kind of you know, further the criminal justice system along. And we're also in charge of mass disclosures. So when there's something that happens that you need to disclose to lots of people, that's what we do as well. So that's a huge undertaking, but we handle that as well with our prosecutors. And you know, that's pretty much what I have right now.
Okay. And last but not least, Mr. Hale.
Yeah, hi, my name is Mark Hale. I head up the criminal review unit conviction review unit in Brooklyn, New York, which is Kings County, part of New York City. I have been the head of that unit since March of 2014. Being a prosecutor is the only job I've ever had. in Brooklyn, and for 25 years prior to my getting on the CRU, I was a homicide prosecutor and tried a lot of cases, and by my lights did pretty well. There was a predecessor unit to the Conviction Review Unit, which was called a Conviction Integrity Unit. The previous elected district attorney to 2014 had been there for 6 or 7 terms. He'd been there for a very, very long time. And he had started in reaction to a particular police detective who had handled a lot of cases, had started a conviction integrity unit. Like some of the other people have talked about here, that unit was extremely understaffed. It had, for the most part, 1 person and then later 2. When the late District Attorney Thompson was elected for 2014, he decided, and he had ran on that, the idea that having a history or a heritage of wrongful convictions was an abomination for a district attorney and for a district attorney's office, that justice couldn't tolerate that. And since we're talking about superlatives, first started, longest continuing, when he formed this up in March of 2014 and put me in charge of it, we became and remained the largest conviction review unit in the country. We have 9 fully staffed, that is, they don't do any other function within the office, assistant district attorneys, none of whom have under 10 years of experience in the office, all of whom would be and have been tremendous assets in other areas in the office, either in the appeals units, in our investigative bureaus, or in our litigation bureaus. And during that time, which is, well, longer than I like to think about now, it's 4.5 years, it's gone by very quickly, but we have examined, well, let me backtrack. We have received petitions on over 500 cases, and those come from all sorts of sources. They come from our friends in the Innocence Project and other recognized innocence projects, including ones that come out of academic institutions, and there's a few law schools in the New York City area that do have innocence clinics. They come from private attorneys. Most of them comes from cards and letters from people that are incarcerated, had been incarcerated, related to somebody who is or had been incarcerated or convicted. And we've received over 500 of those sort of petitions. Out of those 500, approximately 150 have gone through our screening process and then been subjected to a full investigation. And a full investigation in my office means that one of those assistant district attorneys who works for me will be assigned to the case for a full investigation. In addition to the assistant district attorneys I have 2 full-time. I had 3. I'm slotted for 1 more. Detective investigators who all they work on are criminal conviction review cases, and 2 paralegals and a receptionist. So we're pretty well staffed. Let me just put this out there, that when you are talking about or thinking about forming a conviction integrity unit or conviction review unit, it is very much a desire. We've all talked about it up here, and these folks up here are all old friends of mine. We're practically a club, along with some other people out there. Patricia, don't hide from me. But we'd very much like to have uniform standards around the country for conviction review and conviction integrity. But we have found that, one, the laws of the various states sometimes prohibit the idea that we all do things in the same way. But the most important factor is probably the will and the goals of your elected. And I know that Dallas has gone through this because they've had, during the time of their conviction integrity unit, how many? 4?
This is the third.
This is the third, okay.
Administration. Yeah.
Okay, and again, these administrations came in while Cynthia was involved in the conviction review unit along with Patricia. They had different philosophies about how they wanted to do things. Now, we were fortunate in Brooklyn that the philosophy, as I said, was that this was not going to continue, that we were going to correct as many errors as we could, and that we were going to re-educate and change the culture of the prosecutor's office, that was the district attorney's commitment, Ken Thompson's commitment, which has continued with Eric Gonzalez, who succeeded him, and to that end, he committed a lot of resources. Now, I know that a lot of people out there are thinking that's great for big metropolitan counties with big budgets like Brooklyn or Fort Worth or San Jose or Dallas, but what do I do with a smaller unit? I think that the whole philosophy is that your conviction integrity, conviction review unit is an essential part of your prosecutor's office, of your district attorney's office. It isn't as important, and this is when you're going to be talking to the people that control the purse strings, because obviously you can't make these things go without a commitment in terms of finances. But the idea that for public safety and public confidence, and in Brooklyn, like in a lot of other places, and it happened in Cleveland, that there was a criticism, a crisis of public confidence in the prosecutors that were elected, that they weren't prosecuting the right type of cases, or they were making mistakes on the cases, and that has an alarming effect when you think about the people that sit in your jury boxes that make decisions on your very, very important cases. If they have this sort of collateral doubt as to the integrity of your office, you're not just going to have a problem of having had wrongful convictions, you're going to end up with wrongful acquittals, because you will have people that have this continuing collateral doubt about the integrity of your office and the way that you approach the mistakes that we all know have happened. And listen, I've spread the word on conviction integrity units for all the time that I've been working with them. And I've run into prosecutors, elected prosecutors. We don't need to have a conviction integrity unit because we don't make these mistakes, or we get, we take care of the mistakes up front in terms of screening. And that's all well and the good, but that's head in the sand stuff. And it's not so much that you accomplish things. And during the time that I've been working with conviction review, we've exonerated 24 people, 23 men and 1 woman, mostly on murder cases, all of them on very serious violent felonies.
Let me stop you there,
Sure.
Mark, because that's an interesting fact. Being that you can look at your unit and resource-wise, you guys have a dedicated number of assistant DAs and an investigative unit separately that only investigate your cases. What would you say to Ohioans outside of Cuyahoga County about developing a conviction integrity unit or conviction review unit who really would not have those type of resources to work with?
You had to ask me that question.
Yes.
Okay. What I would say to you is that you should marshal whatever resources you have, even if it means you collaborating with people who are in adjoining counties, or a consortium of prosecutors, or engaging outside voluntary investigative panels, which I think is done in Lake County, Illinois, and we're going to be, I think, hearing from him.
Yes.
Here, you're out there somewhere, okay? How you been? And because again, this is where it's going back. The money that is expended on law enforcement and on prosecutors, if it doesn't include an element where you are trying to eradicate these mistakes and make sure these mistakes don't happen going forward, like David said, talking about a proactive thing, then you're not doing your job. You're not doing your job in terms of providing public safety. Public safety is the ultimate goal. Public safety within a just climate. And it should be emphasized that it is just as essential as your homicide bureau, as to your narcotics bureau, as to your misdemeanor bureau. This is a very, very important thing, and that it's not a luxury item. I know that there's a lot of people like, well, if we have the money, then we'll do it. It's not a luxury item. It's an essential item. Because, again, public confidence, more efficient law enforcement, you can change the culture not only of your office, but of your law enforcement agency that's with there. After all, we're the ones that control what gets prosecuted. The police can bring us all the arrests we want, but it's within our discretion as to whether we're going to prosecute those cases and maintain them and incarcerate these people if they have to be incarcerated. So it can't be, you should be innovative about thinking about ways that you can review these cases. Now, as an adjunct, since we were talking a little bit about outside panels, a lot of it is that there's resistance not just on the part of prosecutors or communities, and we found, frankly, that communities, our community was a lot more behind this, a just culture, than we expected. And even though we have a very, very diverse community, we expected certain segments of that community to be behind us, but it's almost universal. And fairness has a lot to do with that. But again, essential element that it has to be done, and we use an outside agency, or outside panel consisting of 3 people who review all of our decisions, whether our decision is to exonerate, our decision is to affirm. Again, this starts building trust within the disparate elements. We have historically distrust between the defense bar and between the prosecution, probably for a lot of good reasons. But again, we can work, and again, working toward justice, if we rebuild that through this sort of thing where we have trust that, again, we understand the defense bar, their obligations to their client and to get the best result for their client. But if they see that our goal is to achieve justice within what their goal is, then we're going to have a lot more cooperation. And again, we're going to have much more sure convictions, and we're going to have much more confidence in our convictions, as well as our dismissals, that we've done them for all the right reasons.
Russell, can I add something to that?
Sure.
Just from a practical standpoint, so you have a conviction integrity unit.
Yes.
So if you have neighboring counties that don't have conviction integrity units, where you have defense attorneys that are trying to get perhaps some level of cooperation that the way they do here, one of the things you can do is ask your prosecutor to call him. We find, because Texas has 254 counties, and a lot of them are small rural jurisdictions. And in particular, Cynthia and I have a lot of suburban areas near us where there are different counties with, small operations. And we will say, call us. If you have a case in that jurisdiction, ask your prosecutor to call and talk to us directly, because who's going to be better able to explain how we can do it in a way that works than us, since we're doing it, right? The other thing that we say is, besides the fact that we'll do training in some of those other jurisdictions as well, but go ahead and figure out what is the need in your unit, or excuse me, in your office, and have that unit start doing multiple things. So in some of the jurisdictions in Texas, they can't get a conviction integrity unit, but everybody's trying to deal with the change in our discovery laws. And so they have what they call disclosure compliance officers. So the disclosure compliance officer starts by helping meet those discovery obligations, but then that's also a person who you can bring in to train in a lot of the things that conviction integrity units are dealing with. And then you kind of get a backdoor way into changing the culture of a place, and to showing that from a practical standpoint, we can do these sorts of reviews.
Well, and there's also, when you're talking about the smaller counties or smaller jurisdictions, I mean, we're talking about being prepared, as opposed to the way we do it in larger counties, where we investigate these cases as a matter of course or a matter of bringing to it. In a lot of the smaller counties, smaller jurisdictions, sometimes it arises from that one crisis case. And that one crisis case pops up, and you're not prepared to handle it. you're not prepared to handle it. You haven't considered the contingency. You haven't looked back at what you may consider a problematic case to try and make sure that that crisis does not occur. And suddenly you're with this crisis, then what do you do about it? Then what do you do about it? And like Dawn said, we have tried in Brooklyn to be as much help as we can to counties all around the country. She talked about the summit that we had. When was that?
October of 2015.
October of 2015, and it's gatherings like this. But I can tell you that as an outgrowth of that conference that we had back in 2015, at that time there were just over 20 of these units around the country. We now have, like Russ said, in the mid-30s out here, and I see a couple familiar faces out here that we've helped from the great state of Florida and Tennessee also. I don't want to leave you out, Robert, but this is the sort of thing where we as a community of prosecutors, and not just limited by state lines, can rely upon each other, not just for advice on how to do this, but also in the heavy lifting of doing it if it happens to work for you.
So, Russ,
yes.
I'm sorry. I was going to add one thing, a potential possibility. I know there was some talk about maybe neighboring counties can help each other out. There's some concern that, just through the years that I've heard some prosecutors express, and that is that if you work in a small jurisdiction, necessarily you have such a close working relationship with your law enforcement agency. And a lot of times it's one of those things where it may feel inappropriate to start doing the investigation for that person, for that jurisdiction, and your key witness or the person that you're trying to see whether they did something wrong is your sheriff or somebody who's going to be a reoccurring witness in your cases from now on. So I wonder, and I've never really talked to anybody else here about that, but in terms of, would there be like special prosecutors, like could you have a special prosecutor come in if you're in a small jurisdiction to come look at cases in your jurisdiction to necessarily take that element of conflict of interest, or maybe not an actual conflict of interest, but an apparent conflict of interest. I don't know. I mean, those are all just...
Ohio's a little different in that you would have to file a motion for special prosecutor with your common pleas judge and within that jurisdiction. And that's kind of a problem with us, and that's statutorily. I want to switch gears just a little bit and just talk about, for the audience, someone mentioned that you get about 500 cases in that you've reviewed. Explain the screening process. You can't possibly screen 500 cases, can you, David?
So what we do for screening, well, first of all, let me say we get a lot less than that. And at the beginning, we got a lot, and especially as you point out, whenever there's a new article, you get a whole bunch of stuff. But over time, and the most fruitful ones that we looked at, I think, were probably from defense attorneys who said, hey, this one case I had, it's always really stuck in my craw. I felt like something wrong happened. And that, carried a lot of weight with us. I got one, though, that was from the convicted person himself, although those tend to be, because obviously been convicted, you've got a huge interest in your case being overturned. So, the accuracy from the claim is less likely than if it's a defense attorney who's picking among all their cases. But in generally what we do then is it's not that hard to look and see if they've got some, because generally we want new evidence of some sort. Because I think people talked about that. I'm not just going to be like the ombudsman, like kind of hovering over every jury trial and, giving a thumbs up or a thumbs down. There's going to have to be something new or some, reason to believe there's something just significantly went wrong during the course of this trial. It usually doesn't take that long to figure out if what they're saying, because I've had some letters that have a pretty compelling claim, and then you realize, in that it's a reasonable claim. They'll say, oh, well, the witness who identified me couldn't have seen me because they were blocked by a building, something like that. Well, but if you find out that was the core issue of the trial, well, there's not probably going to be a lot of point in looking at that because that issue was fully litigated at the time. You know, I do think there has to be an exception to every rule, because one of the cases, 2 people who were exonerated, kind of none of the boxes checked off, and yet, and I think this is the advantage of having experienced people, I just kept on having a bad feeling about this case. We just kept on digging on it, even though there was new evidence, and even though there was all this other stuff, and and then we found other things. But on the whole, you can do a fair amount of quick screening just by, at least in my state, the probation report is usually going to have a pretty thorough summary of what was presented at trial, and that can often kind of quickly get through cases where there's nothing really new.
Well, let's assume for a minute, though.
Let me, if I can just, it often is, and I think that people that have CRUs, that sometimes they limit it to the issues that are raised by the petitioner. And we don't do that, and experience has taught us that sometimes the issues that are raised by the petitioner, when we've investigated them, they mean absolutely nothing. But in looking at the whole case, there's a whole bunch of other things that have come up. I know one that came, and generally these people are better prepared to present claims from the New York Innocence Project, that they thought that there was this dead set, this one issue that would have caused the case to blow up. Mm-hmm. And it turned out that issue was a lot of nothing. But there was this other huge issue that blew up in the course of our investigation that would have remained uncovered if we hadn't investigated it. So again, when you're screening cases, our philosophy anyway is if they've got something to get their foot in the door, we don't just limit them to the case. And frankly, there's a lot of people, and it's the attitude of the appellate courts and in post-conviction motions, is that the defendant is having been convicted is now presumed guilty, and a lot of the burden is on him. Again, since we make our own rules and we're operating outside the judicial process, we remain with the burden on us. Do we still have confidence that this evidence would have proved guilt beyond a reasonable doubt? Because that's the standard, beyond a reasonable doubt, and the burden is on the prosecution. So that's kind of how we look at it.
Could somebody walk the audience through an investigation, an actual investigation? What do you do? What things do you look at? What do you interview people? Do you look at police reports? Walk us through that if you could, anyone.
Well, we have it set up in Tarrant County by phases, because you may get however many number that you get, but that doesn't mean they're all the same. There are some cases that you get that you may be able to determine fairly quickly, don't have the issues that would rise to the level of being able to get relief. But then there are other cases, obviously, that need more work. And when you're looking at your numbers, you can't just say, okay, we got 100 cases and we've screened 85 of them and they had nothing wrong and 15 did. Well, what are you doing with the 85? And you're going to be subject to criticism either way. Are you spending too much time? Are you not spending enough time? How do you know? If the cases look the same, if you start looking at something and you find something else wrong, how do you know when you're looking at it on the front end? So what we did was set up kind of a process, and maybe sort of because I'm a metrics person too, and I want to go back and ask for more people always, so I need to be able to show our work. So what we did was set up kind of a phase. You have a preliminary screening. So we may look at the case originally, we read it, everybody reads it, everybody comes in and you say, what do you see with this? What do you think is here? These are their claims, but you look at the file, look at the claim, see what you think. Then it gets assigned to a person. That person then will go to answering whatever the questions are. So we have questions about this claim that they made. Maybe that can be answered by reading the record, maybe because it has to do with a witness testimony, or maybe it's something that has to do with forensics or the law enforcement file. And so in those instances, you go outside of what you have in your office to those areas to find whatever you need to answer your questions. Then we come back together and it's like, all right, well, do we feel like this is good enough now? And then you proceed from there. So when you get to like a phase 1 review is what we call it, is when you're going outside and you're getting everything that you can about the case, the bench notes from maybe the lab or the police agency file or whatever it may be. And then that may be where you start talking to witnesses. And then when you get to a phase 2 review is where we're doing a full-blown reinvestigation. It means new testing, it means interviewing witnesses. And so when we close out a case, we close out a case at what phase it was at. And that way we have some sense of how much time are the cases taking. Because a phase 2 review in Texas where, and I like to make this joke, so no offense to every jurisdiction except West Virginia and us, but we don't get to click our heels together 3 times and say we take the conviction back. We have to go to the Court of Criminal Appeals in Texas, which is the highest court in the land, and prove to them that we meet the statutory requirements for this person to have been actually innocent. So the defense...
Let me ask you this then, Don. So what you're saying is your standard is actual innocence. Do you take anything outside of a claim of actual innocence?
In Texas, we have writ laws that do allow us if there's constitutional violations. And then we also have, I don't like to call it junk science writ, forensic science writ, because there are changes in forensics that, that may necessitate relief. So we will look at claims that may rise into those categories if we see them as we're looking at the actual innocence review. But you can say we got, I'm not picking on you, but 500 claims, and maybe 500 claims, if you closed every one of them out in the preliminary phase, maybe you're doing what you're supposed to and maybe you're not. But if you have a case that may take 3 years, depending upon your system, which is what Cynthia and I deal with a lot. The last exoneration we recently had in Tarrant County took 3 years to get to that point. So you have to work with whatever of course your state law is, but you have to figure out a way to say how much time am I really spending on these, and are we really looking at all the issues?
Okay. That brings me to my next question then. On the case that took you 3 years, is that because the way that the law is set up in Texas that you have to, is there a court before that? Is there a trial court, for example, where you have to go in front of? And are you petitioning the court, or is this a joint effort?
It depends. In this particular case, the Innocence Project brought it, and so it already had an attorney. But we have other ones too, that are taking, I have a case right now that is taken about the same amount of time. And part of it is getting in line at the lab for forensic testing, and depending upon how much testing needs to be done, how long it takes, do we need DNA and mito testing? And sometimes that can take a while if you're working with state resources, or where it's provided, in Texas, it's provided by our Texas Department of Public Safety, free of charge and post-conviction testing. But there are other things that, of course, you have to pay for. But it goes before the trial court once you've made a conclusion, and then the writ, nobody wants to hear the details of this, but then basically if the trial court agrees with what the state and the defense have said, then it goes up to the Court of Criminal Appeals. The Court of Criminal Appeals then says whether they think that we all got it right. And then it comes back. In our case, it was a combination. It was because it had to wait, but in the meantime, we did additional investigation because we found a due process violation right away. We sent it up on the due process violation and continued to investigate the actual innocence claim while the due process violation was pending.
David, explain to us your investigation process.
Oh, well, I think it's kind of, we don't have to go up to another court. I should say the ones we've had, we just go to the trial court, and we've not had any pushback there. Even in the ones where it just started with us, we try to get a defense attorney, wired into the case, so we'll refer things to the Innocence Project or, whatever lawyer they want to use. And the investigation, I've had the pleasure of working really terrific investigators usually. They're with our office. They're usually have been cops for 20 plus years, homicide detectives. And the neat thing for them is it's kind of the most fun work that they do at some level, because they're a great cop, then they come to the DA's office. They do great work at the DA's office, but a lot of their work is sort of routine. You're asking, so it's sort of the equivalent of like you got a Ferrari and you're asking them to go get you a cup of milk at the corner store. So they can do it. They can find out what time the liquor store closed for somebody's case, but it's not really fulfilling it's not as fulfilling. Whereas here I'll have investigators, I'm like, hey, you just open every door until there are no more doors to open. And that's pretty much what we do. So once we get to it's stage 2, or we're finding new stuff, then you just investigate it, and it's not really that different from an investigation I would have done at the front end, or the police would have done at the front end. I mean, you're interviewing live witnesses. You're doing whatever. You can't. It's like all of us, we're professionals. You can't cookie cutter it. It's whatever you need to do for that investigation. But it takes a while. Just these cases are going to take a while, and we try to have if the trial attorney is still around, we want to get input from them and keep them updated on what we're doing, but we don't really have them involved in the process themselves. Ultimately, this is going to be a decision of the DA's. The DA gets to listen to whoever he wants to, and our DA really likes to get a lot of points of view, so we'll have the original trial DA, we'll have, all of us ultimately present it. But I should say by the end, there's really pretty much of a consensus on the cases that we've had. They're really hard decisions to make, and then it's fallen to me, I think, in all but one of them, to talk to the victims and, kind of try to walk them through what's happened. What's interesting is that, there's a lot of debate sometimes of what legal standard you're going to use, but I think the advantage of being within your office is, yeah, you can call it whatever you want, but the bottom line is, would you try this case knowing this information? Do you feel comfortable with this? And that's where there's a political element to it, because different electeds are going to have different views of it. In the end, you kind of know it when you see it. You're like, yeah, I wouldn't try this case with this information. And then you're done. You're kind of done at that point.
Yeah, it's funny that you mentioned that because, again, about your electeds, in some places, the word progressive is a dirty word. And there's people that label conviction review and conviction integrity investigations as progressive issues. And really, it's not. It's a practical issue. It is practical, and again, that it provides public safety, and we like to keep the door as open as we can to litigants that come in, to petitioners, and you can artificially constrain that, and sometimes there's nothing wrong with doing that if you feel that too wide a net will totally overwhelm the resources that you have. We like the idea that we can have a wider net, because then you catch more of the mistakes that happen. But again, the whole idea is that you try. And in some of these cases, because we don't have any time limit, all of history is what we do, that you simply can't help these people, because, and they may have a really good claim, but the evidence is gone and you can't find it, and the witnesses are dead, and you can't recreate what they're going to do. On the other hand, we had the opportunity to go back to 1964 conviction on a guilty plea and exonerate the guy. So, if you have the resources and the commitment, you can find it, and it's whatever philosophy you have.
Explain the concept, if you would, for the audience, what we term as, I heard it earlier, someone said junk science, and that leads to wrongful convictions. You want to take a stab at that, Cynthia?
So junk science is what, people often think of as bite marks, hair microscopy, things like that were going on. Probably a lot of the cases in Dallas, that involved hair microscopy were prior to, the advent of DNA testing or the use of it more routinely in the 90s. And, those led to a lot of wrongful convictions, I believe, because there were, obviously DNA testing wasn't available, but some people kind of took it a little step further. Some of the analysts took it a step further and maybe added their own twist, or maybe added some statistics onto their testimony about, how certain they are that this is the person who did it based on their comparison of the hair or the bite mark or something like that. So that's what people call junk science. Now, in Texas, there's a statute called 1107-3. That's, post-conviction, which is what Dawn was referring to earlier. And essentially, that's kind of, some people call it the junk science law, but really what it is about forensic advancements. And there's, always, science is always constantly evolving, but really it's changes in science or changes of your expert when they might have testified a certain way today based on their training and experience, and they go back and review the case, they would not have testified the same way, that they did back then. And so that could be one of the bases for relief. And so that's a fairly new statute in Texas, but I'm sure it's going to catch, on with the rest of the country, I would think.
Could you send us a copy?
Absolutely.
Do you mind if I just jump
Sure,
in?
go ahead.
I wanted to just build off what you said, because something you said I really believe strongly in is that I don't like the term junk science for the same reason. And it's not because I think that everything that was presented, there was some stuff that was just clearly one step beyond made up. I'm not denying that. But the problem is once you put that category in your mind, well, first of all, people are going to be very defensive. Like, well, I didn't do junk. And secondly, it's like it kind of misses the whole point. Like, science is supposed to evolve. Like, that's its best feature. And if you define, well, the only time we're going to look at it if it's junk, well, that's really not only you kind of creating divisions that you probably don't need to create, but you're excluding most stuff. If instead what you say is, look, I expect science to improve from year to year, at some point you're going to have improvements such that you would not, this evidence was deemed reliable at the time is no longer deemed reliable. So you want a mechanism to go back and look at it. And I think if that's a theme of maybe the panel that happened before as well, a lot of these things are really not about, look, there's more cases there's more wrongful convictions due to ineffective assistance of counsel, right, than there are due to prosecutorial misconduct. But nobody thinks the defense attorney had some secret agenda to try to railroad their client. I'm not saying it never happens, but it's just, obviously they made a series of mistakes. Well, it's the same thing. So I think to think of it is if you have a crime lab and you want it to be scientific, that means you have to have some mechanism of how you're going to look at old cases whenever there's a new improvement in the science.
Is there any difference on how you would handle a DNA case? We all know about the famous case of Jennifer Thompson, where that was an eyewitness case, where she was raped as a college student, unfortunately, and she did everything in her humanly possible way to make sure she could study the perpetrator's face and knew his eyebrows and knew his chin and was really detailed on how, as a young college student, that she was able to do this. And what we would deem as a very credible victim, okay? Is there any way, when you look at a case like that, and then you find out, wow, DNA has exonerated the person 11 years later, I want to talk about, do you handle the DNA cases any different than just, say, a completely different scenario where it's just an eyewitness case?
I'll say no. I mean, in Dallas, obviously, we're known for our crime lab kept a lot of the evidence in cases, and that's one of the reasons why we were able to have a lot of DNA exonerations at the beginning of our existence in the CIU. But I say no. I mean, we don't handle them any differently. If the evidence is there to be tested and it's, something that we can do by agreement, we have letter agreements that we can execute with, the Innocence Project or the defense attorney that's representing the person who's petitioning for this. We can do that outside of statutory constraints in the CIU, and we do those fairly regularly. If there's DNA to be tested, we have no reason to say no. We will do it. There are some people who say, well, why would you do that if, you can open yourself up for challenges? There's an unknown profile that comes up. Doesn't necessarily mean it's the perpetrator, but then that gives that person the ability to go in and litigate in court that, yeah, that was probably the perpetrator, but it wasn't me. And, for people who ask for that, to ask, about that concern, I say, just agree to test the evidence. In our letter of agreement, we specifically say, just because we're agreeing to test the evidence doesn't mean that it's necessarily we're going to agree that it's exculpatory or anything like that if it comes back a certain way. We're just simply putting forth the mechanism. We will do it jointly Okay, we will send the evidence, and we all, both the state and the defense, we both have the ability to speak with the analyst, with the lab. We test, if there's something that we want to test for STR and we think that it would benefit from YSTR or MITO, then we amend our letter of agreement and we say, okay, we will do this or we'll do that. And we've not had any problems in Dallas County from doing that. There
you
are
have a
times
more
when we
open-
disagree what it means, but that doesn't mean that we stop doing it for everybody else.
Anybody any different on DNA cases?
The only, just to amend what was just said, we have a statute in California that allows for it for pretty much any case, but we have had, we really just want to get the evidence. We have the same philosophy. So we've had cases where I've said, look, I can't agree that this qualifies under the statute because I don't think it's going to make a difference. But, you know, DNA testing just isn't that expensive anymore. So it should be an expense that either they can come up with or you can absorb to make it happen. And on the whole, I think what's really good about CIUs is that, you know, you want to get to the merits. You want to reduce the amount of fighting you have over sort of jurisdictional or, you know, I mean, so I couldn't agree more. Like, yeah, just test it, and then we can discuss what it means afterwards.
Yeah.
And really, in the big picture of things, and I think it's all of our experience, and I think Rebecca would agree with us, in the universe of all these cases, the cases that are DNA determinative, that's really the game breaker, despite the perception of the public, is really a very, very, very small number. So, you know, when we're talking, we've had one DNA exoneration because it was a DNA-dependent case. And I guess, truth be told, that as DNA science has gotten more discriminating, it's become less probative in a criminal sense in terms of saying who did it, who was present, who wasn't present. And so, you know, I think that we are progressing past where DNA is the magic bullet that's going to tell us whether you have a wrongful conviction or not. We're going much more on subjective fact analysis of what happened in the case and whether we should have put our trust in certain evidence.
And because we're testing so many different things. I mean, if
yeah.
you're testing blood or a sexual assault kit, you know, then
Well, that's different,
sexual
yeah.
assault kit probably is going to, you would assume, most of the time,
Outcome.
absent a consensual
A
person,
single
it's going to
donor,
be
sure.
outcome determinative.
Yes.
But when we're talking about touch DNA or just a lot of evidence that's gathered, that usually is just one piece of the puzzle, and it's not going to make or break
Yeah,
what
and
the probative
the
is.
touch DNA scares the heck out of me, as it does a lot of people. But
I mean, because we know that there's issues of contamination if an article is sitting for years and years in a box in a corner.
Or gathered
of a-
without gloves.
Yeah.
Or
So
We
testing that.
our county was the one where we had the case of the gentleman or the individual who was, I mean, this came out, you know, prior to the trial, but, you know, essentially what happened is there's a transfer from defendant earlier in the day to the EMT who treated him, to the EMT back to the victim of the crime. And, you know, so that can happen. And you just, you know, now that you know that, you just to be aware of it. But I think you're absolutely right. I mean, it's kind of funny. We have one case that was DNA, and it wasn't really outcome determinative. It was really just one piece in a whole lot of other stuff.
When you screen through all of these cases that you're looking at and you go through an investigation and you find it's just simply not there in your determination, is it best practices to write a letter to inform the petitioner or applicant that why you actually denied their petition?
does anybody do that? Does anyone do that? Does any CIU in here actually explain why they deny it?
I do.
Okay.
Okay.
I'm just curious. Like, you go through your whole case and talk about what you reviewed and why you reached that conclusion.
I don't write a 10-page memo, but I write a detailed letter that gives an overview so they know, they can have confidence that we worked on it and didn't just dismiss them without doing anything. It depends on the case. Like, I had one guy who said he was the wrong guy, he was there under someone else's name. So we went through a 40-year, roughly, a long criminal history. We pulled prints from every jurisdiction where he'd been arrested, and we pulled mugshots from every jurisdiction where he has been arrested, and determined it in, because in some old cases, people just use people's names. He could have been, I mean, it is
It's possible.
He's there under someone else's name, and he's not the perpetrator. So I made a chart for him with all the mug shots and all the thumbprints. I happen to be fortunate enough at the time my investigator came from the forensics lab and had a history of looking print investigations. So he just did it himself, compared all the fingerprints, and they all matched. And I sent him the chart with all the pictures and all the things and told him what we did. I'm done.
So I'll say that, when we've had cases where, we've done that. We have pulled, fingerprints or, whatever it is, documents that would be able to kind of disprove what the person's claim is. And then, one time we sent the person a letter and we said, we are not going to investigate your case. Here's the information that you asked for us to pull. It shows that you were actually not in jail when the offense occurred, like you claimed. So, here you go. Do with it whatever you need to and have a nice day. Well, he claimed, that we had falsified these records. And we're like, we did not falsify the records, but you can go file a writ of habeas corpus and challenge the case. Just because the CIU said no, we're not going to review the case, doesn't mean you're over, And so we always have to be very careful. We typically send more generic letters, because the other thing that you have to think about is you don't want them. A lot of times people who ask for reviews, inmates, for example, they may not realize that you work for the state. They think that you're the Innocence Project, even though you tell them in big letters, we are not your attorney. You can say it all over again in many letters or correspondence, but it just goes back to, you cannot have this potentially construed as legal advice or something that they can interpret that they are barred from pursuing claims on a writ of habeas corpus. So we will say, we have reviewed documents in your case. We are not able to investigate your case at this time. You are free to contact an Innocence Project or an attorney of your choice to, get advice on the best legal route for your case, if any. And we can't give you any legal advice. We work for the state.
Okay.
Here, that's it. We close it.
Now, I want to go back to this subject because it's pressing. In a lot of literature, we hear a lot about the DNA cases and how 70% of those cases, those exonerations, were from eyewitness misidentification. What can we do as prosecutors to safeguard from these eyewitness identification issues? Mark, want to take that one?
Sure. I think that obviously the video that we saw and some of the comments that we saw in the previous panel are very, very helpful. And I know there's a lot of controversy about whether these things should be presentable during a trial, the various science. What they are helpful with, and the way that we utilize them in a CRU and the way that we're trying to get them to be used within our office for all prosecutors is looking at them to inform them. And when I say inform them, again, during the previous panel, there was talk about how errors occur. My experience from looking at these cases is that the errors are not so much bright line ones about, I hid the Brady or the cop lied about something. It's more in the lines of judgment. Were you exercising good judgment, Mr. Prosecutor, when you chose to stand behind and present as truth this particular piece of evidence? If it's eyewitness identification or if it's a confession, were you exercising good judgment in your prosecutorial discretion in using that particular evidence? And what this sort of thing does, and we're talking about eyewitness identification, is prosecutors being able to recognize the factors that go into an erroneous identification, to be able to look at them and then look and transpose them to their own cases before they make the judgment that they're going to present this purported eyewitness as being truthful and accurate. And so I think that's the best utility when we're talking about things like eyewitness identification. And in our particular unit, and we've tried to expand this, we contact these people and we ask the experts, about things that we might suspect, but we don't necessarily know about how an eyewitness might be influenced by outside factors or their own observations, and the whole hypothetical about, well, they said this when they described, they said this when they described the incident, they said this other thing, and then they were shown the photograph for the lineup, and they identified what effect that these other things have. Because, again, I think there's almost been too much emphasis on the idea, and you talked about confessions. Why would an innocent person confess? Well, we know that there's a lot of other reasons for that. And it's like, why would a person who was victimized, why would they pick the wrong individual? And it goes much more and much deeper than what we understand from the common law and the statutory law and a lot of jurisdictions where juries are instructed that they're to consider the length of time that they had to look at, whether there were any obstructions, what the lighting was. It's a lot more complex than that because it really has to do with the mental operation of the person, not just on what is bare bones common sense consideration about why a person would do this. So again, what we like to do, and that's part of our proactive factor, and so proactive that it goes actually to our hiring processes, where we're not just looking for people that, graduated from a good law school with high grades and everything. We're trying to test them to see whether they've got good judgment. And so what we're really looking at and how these things have affected us in all areas is, did the prosecutor exercise good judgment in how they prosecuted the case?
Don, if you could take us through, you mentioned earlier jailhouse informant legislation. Can you and Cynthia maybe tag team this question, which is, what exactly is that, and how can we, as a group, trying to learn best practices here, deal with that type of legislation? How did that come about?
So basically, we had it's interesting because the case came to the Conviction Integrity Unit because of DNA on a knife that was not the defendant's, that ended up to not be relevant or probative in the case by the time that we got done with the whole thing. But in the course of reviewing it, we determined that there was a jailhouse informant in the case who had said that they didn't receive a deal, and they did, and that had said they'd never offered to snitch on anyone else, and in fact had offered to snitch on 8 other cases, and had testified in a capital murder case 5 months before. So that obviously was a problem. And what it got me to thinking is, we need to figure out how to make sure that doesn't happen again, because guess what? They're not always going to tell you the truth about what they've done before, right? And prosecutors hopefully will have the experience to be able to ask about all of that and to ask the right questions and to research it, but everybody's busy too. And the level of research on every witness maybe the scope can't be as broad as we would like it to be. So what we said was, we need to have a database, at least in-house, where we can track, have people testified, and have they offered to testify? Not just have they testified, but have they offered to testify? And what information do we have about those individuals that another prosecutor needs to have available in order to make a judgment call about whether to use them, and needs to have available in order to disclose, so the defense can do their job in properly cross-examining, and the jury can do its job in determining the credibility of that person. So it was a two-pronged thing. We have this tracking and this database, but then also you realize that, in the 90s, we used a lot more jailhouse informants than the prosecutors use now, I think. And so a new prosecutor may not know what a jailhouse informant really looks like, or how charming they might be, or, you know, all the information that they are perhaps not having as much experience dealing with jailhouse informants to know. So the other thing we did was set forth what are the best practices. So we made the best practices of jailhouse informants, and we gave a very comprehensive list of things to consider when you're using a jailhouse informant, and things to disclose to the defense about that person. And the part of that being, I came from a jurisdiction, not Tarrant County, where there was a lot of wink, wink, nod, nod. You know, they're not really getting a deal. And in Tarrant County, one of the things is you will polygraph them, you will enter into the plea ahead of time, you will proffer everything they're going to say, you will do the plea in advance, and what they're getting is going to be available, and it ain't changing once they're done testifying. And so if the defense has all that information, they can really do what the defense is supposed to do, which is attack the credibility of that witness, if at that point you've even decided to use it with, which honestly, it's fairly onerous. So once you've gone through and vetted whether or not the jailhouse informant has done that, which usually they have done it before, when we do our tracking now, it's been very eye-opening to me that we will have a certain number of offers, and how often the offers come from the same people over and over again.
So is this more of a statewide database that all the counties in your jurisdiction or within the state can have access to, or how does that work in practice?
Each county has the capacity to set up in whichever way that they think works for them. I mean, in some jurisdictions, maybe it's an Excel spreadsheet. You know, you got 2 prosecutors in a jurisdiction, you may be able to just historically record it so that the next people coming in know. In a jurisdiction that's larger, and like Cynthia's jurisdiction as well, we have an electronic case management system. So when we get discovery in a case, we just click a button and open it to the defense, and they have everything in the file that we have electronically. And so we use that system in order for us to also track our jailhouse informants by tagging them. Tarrant County is a little different because we've had an open file policy since 1974. And we've had an electronic case management system where we give the discovery to the defense since the early 2000s. So we are able to use our technology to help make a lot of that information available. But you can do it with this spreadsheet.
How would County A know that this person was an informant in County Z?
You don't. There's no interaction between the county databases. There's no
Unless we
state
call.
database, unless we call, that's right.
Yes.
Okay.
And you would assume you can look at the criminal history and say, okay, they've had 5 convictions out of these 5 other counties. Maybe I should call and ask.
But there's no interaction between like a per
not
se
centralized.
large statewide database, no.
How crucial is training your prosecutors within your office? It sounds like that system there deals more with Brady and our obligation to hand over information or Giglio information to the defense. How do you put your prosecutors through specialized trainings to know how to navigate through this system that you're talking about?
I stalk them.
Okay.
That's what I do. Have you used a jailhouse informant? Have you talked to a jailhouse informant? We have it set up in our office where all kites come to me, and we track all of the kites that we get in the office through every court system. I mean, every one of the courts. They have to send it to us so that we can keep, because otherwise it's going to be difficult to keep track of everything.
Okay. All right. When you're going through your investigation and looking at these potential wrongful conviction cases, do you share the discovery in the spirit of collaboration with the defense? Meaning the person that's representing the applicant or the petitioner who wants you to the relief from your unit. Do you share discovery during this process?
We have a discovery, we have an agreement first to review files. So you have to represent this person in your capacity as an attorney to review the I guess, the legitimacy of the claim. We open up our files, our trial file, our appellate file, our writ files, our DNA files, whatever files we have, we open it up to the defense. If the case moves forward for an investigation, we have not yet established a written policy, but we have an understanding that we'll share information openly, and we hope that we get the same reciprocal. And most of the time we do. There's only been one time where we, and it was one particular attorney, and they did not understand or believe in the collaborative system. And so they didn't really share anything with us. And in fact, when we complied with our obligation and provided discovery, they went ahead and released information, even though we had told them, please do not release this, it could compromise the case. They went ahead and released it to their client, and there were other things that happened. And at the end of the day, it did not compromise the case, but it made us open our eyes to maybe we just need to have an agreement. Dawn has an agreement in her office. We don't have that because it had never happened to us before. We had operated for over 10 years without having any issues. And then it happened. And so now we're going to have to establish some kind of written policy or a written agreement that people are going to have to sign that, when you do innocence work, it is so different than a normal case that you go and investigate. It is completely 100% different. When you're doing innocence work, your post-conviction investigation is so delicate because most of the time, many years have gone by already. People have been talked to in various stages of past litigation, and so you really have to create a pristine environment as much as you can with your new investigation that's ongoing, and you need to really be protective of the integrity of the investigation. Specifically in Texas, when we send it up to the Court of Criminal Appeals after it gets presented to the trial court, that carries a lot of weight. When the state can say, we have done X, Y, and Z, and we believe that this case, is an actual innocence case for these reasons, and you feel it's a much better system when you have people who understand how to investigate and how to cooperate in actual innocence cases.
How would you all respond to the criticism that you're operating these conviction integrity units as if you're a 13th juror? Person's been accused of a crime, indicted, had a lawyer, went to trial, convicted, and now you're looking at this case again. How would you respond to that criticism? David, you want to?
Yeah, sure. Well, that's a valid concern, but the way we look at it is, so we will have plenty of cases we investigate, I'm sure we all have, where it's kind of a gray area. And I've had some where I'm like, gosh, I don't know, if I was in the jury, I probably would have said not guilty. But that's not going to be enough. And the reason and that's when I talk about the new evidence. New evidence, either they're going to be new actual evidence of the crime, or sometimes it's new evidence of some real misconduct or breakdown that happened. So that's new as well. And so that's really, I think, where the community would have faith in us. We're saying, hey, we're not just coming in and you have a new DA who has new views, so suddenly everything is up in the air. It's more that you have to have something substantive, some actual new evidence that you're looking at that causes doubt about the conviction, or you find out new stuff. And that's where I said before, like if I look at a case and this exact issue is heavily litigated at the trial, well, it's really not up for me then to say, oh, I've looked at it and I feel differently than all those people did, who, by the way, heard live testimony, right? I'm just looking at a paper record. So I think that's a totally valid criticism that you have to substantively respond to, not just kind of spin your answer.
At the end of the day, though, too, and of course, we don't have this issue at the same level as y'all because everything has to go to the Court of Criminal Appeals, and so there's very specific standards, and so by the we kind of get like a stamp of approval in some ways. But in particular, like in the recent case that we had, it went up on due process and came back, and then you have to make a decision. Are you going to prosecute it? Are you going to dismiss it? If you're going to dismiss it, is it because of actual innocence or not? And at the end of the day, you are elected to do, the district attorney is elected to do the job. And we use discretion all the time in what to charge and what not to charge and whether we're reducing charges and why is it any different? We're using discretion about, is this something that meets the elements of the law? Do we believe that we can stand behind this verdict or re-prosecuting or whatever it may be? And if you can't, then you make a decision with whatever you think is the truth and what's right. And if the public doesn't like it, then they'll elect someone else.
Well, let me pose this question then. You're investigating a case, and if the prosecutor is still in your office or outside your office, and it's a 15-year-old conviction, during your investigation process, what is the best practice? Do you get their input, being that their conviction is the one that may be overturned later, potentially, or you leave them out of it?
Who?
The prosecutor that handled the case, and you're investigating that particular conviction.
We don't contact the trial prosecutor.
Is that best practices? Does everyone agree with that, or?
We don't contact them either. Everything that prosecutor had done during the case is part of the record. It's either in their work product notes or it is in the actual trial record, or their answers to motions or any other notices that were made to the court and stuff. And frankly, if there's something that went on that isn't part of any of those things, then he's got a problem. And you don't really need an explanation for it because it's on what he did or what he didn't do, and you can plainly see all of that from the paper documents. That's if you get all the paper documents. And obviously in a lot of these cases, especially historic cases, it's hard to get everything in terms of all the paper and all the evidence on the cases. There may be some situations where there is a hole in what you've been able to gather that may be able to be filled by the trial prosecutor, but very seldom.
So,
Two caveats. I'm sorry.
no, I was just,
Two caveats to that real quick. One is we have internal referrals, so we have prosecutors who will refer cases to us. And if that's the case, I do ask them questions about it, because obviously they thought there was a reason we needed to look at it to begin with. If it's a Brady allegation, you have to go to a trial court, at least in our jurisdiction. If you're presenting to the trial court may want to hear from the prosecutor. And so there may be instances where you do need to ask them about things, or it may not be documented in the file, and the court wants to hear from them.
that was what I was going to say. The only time that you do go is if there's a due process violation that when you send it up to the Court of Criminal Appeals, in fact, we had one where it was pretty clear from the record what had happened, but the Court of Criminal Appeals, before they made a finding, pretty much saying that this person committed prosecutorial misconduct, they wanted to hear from the prosecutor themselves. So we held a hearing, and Patricia was there, and it was very interesting what happened, because he gets up there and he defends himself, right?
The prosecutor who handled the case.
Right.
Okay.
But it was obvious from the records that things were not as they were being presented at the time, and so we had that's kind of a battle that you have to fight only if you need to. But on the run-of-the-mill kind of case, we don't contact the prosecutor.
Because this might be the one where, so I'm the odd man out, because I will contact them in every case. So they're not part of the reinvestigation, but I want their input. Now that's going to be if we're actually investigating it. So I don't contact them every time I get a letter, but I'll send an initial email or letter out, depending where they are, just saying, hey, we've got this case. We're looking into it. At this stage, I have no reason to believe that it's an invalid conviction. I have no reason to believe, we're just looking with fresh eyes. I'm going to keep you posted about anything that happens. And at some point, I'm going to ask for your input. And we do this for a couple reasons. One, it's just as a practical matter, you're often going to need to, right? Because hey, they're saying they didn't hear, was there ever any supplemental police report? Well, because often we can't find stuff. It's an old case. It should all be there. But if you can't find it, there's a good chance they're like, oh, I have a duplicate. It's in my, so it's actually just very practical. Secondly, there's often these things are mixed where you have both just a plain out innocent claim, like, oh, I've got a new witness. But others, they're like, hey, this was unfair, that was unfair. Well, I got to know, because they'll often be able to say, wait, that's not true at all. I sent them this evidence on this date, here's the letter that's showing it, or, here's what happens. And it's fine if it's a digitized file, we should have it all, but, we sometimes don't. But I would say the bigger reason is not so much because they're going to be of practical help, although often they are. It's because what I said at the beginning, I want to create a system of trust within the office where you're recognizing like, hey, there could be mistakes made. Just because you had a case and there's a mistake doesn't mean you're a bad person or a bad prosecutor. I want you to talk candidly about what happened. And the last exoneration that I had went the smoothest of them all because a trial prosecutor said, you know what, hey, I'm glad, first of all, before we even went forward, I said, I'm glad you're looking into it because I've tried a lot of cases. If there was a mistake made, I want to know about it. So I'll tell you what I know and you let me know what happened. And at the end, she said, well, if I had known this, I wouldn't have taken the case out, which made, and it was a very controversial, let me say it was a very controversial case for an exoneration because it wasn't, it's like you said, it was subjective. It was, it felt like sand sometimes. I mean, we were convinced it wasn't a good trial, but I wasn't really sure. It made it a whole lot easier when I went to the elected DA and it said, hey, and the person who tried it, she's told us that if she'd known this, she never would have done it. And so I think it really fosters a lot of trust for people to know, hey, if we're looking into something you did, it's not going to be behind your back. You're not going to read about it in the paper or in a disciplinary hearing. We're going to let you know every step. And if there's an issue, we're going to let you know. So it's kind of worked for us, but I do want to be clear, they're not part of the actual process.
I misunderstood the question because we do that too. I contact prosecutors about cases that I thought you meant, are they part of the process?
Oh, well, maybe I was misunderstood.
No.
Let me ask this because I know we're running a little short on time. Compensation, wrongful conviction compensation statutes. I don't know if you all have one or not, but I just want to address this issue, at least before we open it up for questions. If you don't hypothetically, as an elected prosecutor, that if I look at this case and I agree on an exoneration, for example, in our jurisdiction it's a little easier, just as in Brooklyn. We don't have to go through a two-step process. But nothing's really easy, really, right, in these cases. But you have a situation where if I let this go, then I'm looking at a $5 million lawsuit. And I can imagine, Mark, in your jurisdiction, where you've let, I think you said upwards of 20 murder convictions have been reversed?
Yep.
Tell the audience, if you would, does that have any play whatsoever in making the decision in these cases?
Absolutely not. If you start thinking about whatever compensation that people are going to get, and listen, I've heard this from people, inside and outside the office. Oh, who are you going to make a millionaire? Who are you going to do this? If you start thinking about,
You saying your own colleagues?
oh yeah,
Okay.
yeah. I mean, if you start thinking about, and I got to say that within the framework, and apologies to our exoneree who was here today. I mean, a lot of the people that we've exonerated they're not guilty of the crime for which they were convicted, but by no stretch of the imagination are they great guys. It might be said, so when somebody comes to me and say, you're going to make, this criminal, this bad guy, a millionaire, they may not be far wrong. I mean, because they didn't commit that particular crime, but they haven't exactly led a blameless life. Nevertheless, if you start making considerations or making it a factor in your determination about whether the person will be compensated and how much they may be compensated, then you're really straying from what you should be doing, which is calling the balls and strikes about whether you have confidence in the evidence or not. Because, I mean, we don't go into prosecuting the case when we're starting the prosecution thinking about, whether the victims will be able to get compensation, or whether if we goofed up, whether the defendant will make the compensation. It should be within the four corners of the evidence that you can determine.
Okay.
I've got a question.
Sure.
Mark, could you comment on how you write your reports? We had talked briefly about that.
Oh, the reports that we write?
For the ones that where you feel that there should be an
Go ahead,
exoneration.
Mike, this Mike.
Would you comment on how you write your reports up in cases where you feel there should be an exoneration?
Yeah, sure. I mean, we make a report that it's work product that is confidential to the district attorney and to our independent review panel, in which we review all parts of what happened during the trial. We'll review everything that we did in the course of the CRU investigation, and we do an extensive section on our analysis about why we think a particular case should go a certain way that justifies our recommendation. And that stands as a record of what we've done for these cases. Plus, it informs in a very detailed fashion what our opinion, our recommendation, and again, it's always subjective, but the underpinnings of it for the independent review panel and for the district attorney. And by no means is that conclusive, because the independent review panel could reject our recommendations, and the district attorney could disregard our recommendations, but it stands as a record of everything that we've done in terms of the case. And oftentimes that's a very, very large part of our investigation, is crafting this closing or recommending document, because again, while they're confidential, we can't say that they won't become part of the public record through a Freedom of Information petition, or that in fact they may become published at some point in time in the future. So again, this is sort of a thing that if they do become public, that it's very, very transparent about why we decided what we decided. And we do those not just for the cases that we exonerate, we do those for the cases that we affirm. So again, that there is something out there that shows in detail why we decided the way we decided in terms of our recommendation.
Hey, Russ, I'm sorry, let me jump in. So I've been at these panels before, and I'm kind of astounded that any of you are still here at 5:25 p.m., but I can't be, so I'm going to have to run and go get my flight now. But I mean, no disrespect. If you have any questions for me, please email or call me. I'll be, happy to talk, but I'm going to have to go. So.
Well, on that note, any questions?
I'll see you, Dave.
I think we're done.
It's the longest.